Thank you for joining our webinar, The Impact on Whois and Intellectual Property Enforcement. My name is Brian Costello, Marketing Manager for MarkMonitor, and I'm excited to be joined by my colleagues, Staten Hammack, Vice President, Global Policy and Industry Development, and Sherry Hildebrand, Global Relationship Manager for MarkMonitor. Today we will discuss what the new Whois model will look like and how brands will protect their IP rights under the new Whois model. So without further ado, I'd like to welcome Staten and Sherry to our presentation. Staten?
Brian, good morning, good afternoon, and good evening, everyone. Thanks very much for joining us on this probably third GDPR webinar we've done. Hopefully you all aren't completely sick of hearing the acronym GDPR, but unfortunately it can't be ignored, and we're doing everything we can at MarkMonitor to address the impacts that it has on Whois and on brand enforcement efforts. Some of what the material that I'm going to cover today has been covered in a couple other sessions, including MarkMonitor summits and symposium recently given in New York and London, but I did try to update all of these slides to give you the current view of GDPR now that the enforcement date has come and gone, which was May 25th. So here's what I'd like to cover today in this particular webinar. We're going to talk about why, again, GDPR has an impact on Whois data and why this is so important for all of us who are in the brand protection and brand enforcement space. I want to talk about the temporary specification for registrant data that ICANN passed just before May 25th and which actually went into effect on the same day of enforcement, May 25th. I'd like to share with you some developments we've seen since that time and the impact on enforcement and brand protection efforts. Also, I'll recap what we did here at MarkMonitor to prepare for GDPR, the mitigation plans we put into effect, and what we're doing now to monitor those impacts. And finally, what we'll do is we'll talk about some advice we can give you as brand owners to enforce your IP rights in this new Whois data landscape and take any questions. So what is GDPR? I don't think we all need a primer on that. It's a privacy regulation that was intended to harmonize privacy laws across Europe. It became effective on May 25th, just a few weeks ago. It applies to data subjects that reside in the European Economic Area and applies to the personal data of natural persons. And this is, I mentioned these two key points because we'll see that what happened, though, in terms of impact is that the scope of the GDPR was expanded beyond its original scope. But this was the original intention and scope of the GDPR. Data subjects residing in the EU and being of natural persons, that is not a legal entity like a corporation. GDPR applies to the collection, retention, and processing of data, which must be adequate, relevant, and limited in its purpose, and done with the consent of the person providing that data, which we call the data subject. Violation of following GDPR regulations can carry stiff statutory fines and penalties. So that is why it's got every business in every industry in every market looking at GDPR because the risk of non-compliance could be significant. So why do we talk about GDPR and brand enforcement at all? Well, GDPR has forced ICANN and domain name registrars to re-examine its data collection requirements under their current registrar accreditation agreement. So right now, when it comes to registering a domain name, you are requested by your registrar who sells you the domain name to provide information essential to the provisioning of the domain name and operation of it, which includes collecting the name of the registrant, email address, physical address, phone number, and that type of information, which is passed pursuant to an ICANN contract requirement to the registry operator and a data escrow provider. And historically, up until May 25th, registrars and registries were required to make that data publicly available in the form of Whois. And that Whois data, as many of you know, is relied upon by enforcement entities, brands, trademark attorneys, and other organizations who are trying to prevent abuses online to identify who's behind a domain name or a website. So when Whois is changed, that obviously changes the nature of enforcement work. So because the Whois database did collect personally identifiable information, it was not compliant with GDPR, according to legal opinions. So prior to May 25th, the date of enforcement of GDPR, ICANN approved the implementation of what they call a temporary specification for registrant data, also known as the temp spec colloquially. And what that aimed to do was provide guidance to registries and registrars on what information could be hidden to comply with GDPR requirements and what information still had to be done. And I'll run through that real quickly for you. First of all, in terms of the temporary specification, it still required registrars to collect the full Whois information as they have always done, and to transfer that information to the escrow providers and to the registry. That is still a requirement of the temporary specification. The data retention requirement is 2 years from the life of the registration. In other words, when the registration expires, registrars are required to keep that for an additional 2 years. And here's where, and in terms of the applicability, this is what I was mentioning earlier in terms of the scope. So the temporary specification said that the hiding of registrant data, email address, name, phone number, and that sort of thing, had to be applied, of course, to residents in the European Economic Area, but that could also be applied globally. That is, to people beyond that, to individuals beyond that. And it could also be applied to legal persons. So ICANN permitted registrars and registries to actually apply the temp spec beyond the original intended scope of the GDPR requirements. Why did they do that? Well, in part, it had to do with a pragmatic and practical issue. It was very difficult, and is difficult, for registrars to validate at the time of sale, you know, whether somebody is a natural person or a legal entity based on simply the information that they provide without actually doing, you know, some sort of due diligence. And same with identification of where they're located. So registrars and registries strongly pushed ICANN to help them out with letting them apply this globally. Then what else does the temp spec look like? Well, in terms of what is now published related to the registrant, the information there's only 2 bits of elements. One is the registrant organization, if applicable. In other words, if there's an organization name, not a natural person name, that can be displayed in Whois. And then the registrant state, province, and country is also available so that you can identify at least where the registrant is located if you want to bring any kind of action, legal action or whatnot. You'll at least know the jurisdiction that they're located in. Registrant email address is, of course, not available any longer. However, the temporary spec does require that registrars build either an anonymized email address relay or a web form by which you can submit a contact, you could submit a notice or some other form to the registrant. So while there's no direct way to contact the registrant, there is a mechanism by which you can still send breach notices, trademark infringement notices, cease and desist letters, and that sort of thing. No registrar email and fax, admin and tech contact names are also not available. There is also a requirement that the registrar must offer a registrant an opt-in to publish their full Whois data. So for those of you who are clients of MarkMonitors, you saw prior to May 25th, you should have received an email from us asking whether you would like to opt in and have your full Whois data published. And finally, an important element of the temp spec is a recognition that registrars and registries provide reasonable access to third parties who have a legitimate interest in seeing that full Whois data, where such interests are not overridden by the rights of the data subject. So ICANN did not provide any details, unfortunately, with respect to whether what is reasonable, I should say, what is granted reasonable access, and they sort of left it up to the registrars and registries to determine that. That's a challenge. But the ICANN community is working on a long-term accreditation and access model, a centralized model that can be implemented by all registries and registrars to provide some clarity as to who gets access and how they get access. And I'm going to speak to that in a little bit later on in our presentation. But I'd like to turn the ball over to my colleague, Sherry, who will share some of what we're seeing in terms of the developments after May 25th and the impacts we're seeing after May 25th. So Sherry, take it away.
Thank you, Staten. The temporary specification became enforceable for ICANN-accredited registrars and registries on May 25th. Since this date, ICANN-accredited registrars and registries have to be in compliance with the temporary specification, or at least able to prove they are making their best faith effort. As a direct result in the temporary specification, we've seen a major shift in the Whois data, and overall, we've seen a fragmented patchwork of different forms of outputs. We've seen a wide variety of outputs from ccTLD registries, with some keeping their full Whois intact, while others have stopped showing all the data fields. For gTLDs, we have seen a completely fragmented Whois, where the public no longer has access to the full Whois data. Due to the temporary specification, registries and registrars have to amend their existing registry-registrar agreement, otherwise known as the RRA. And over the past month and a half, we have received more than a dozen amended RRAs and will continue to receive many more for the next couple of months, as there are hundreds of RRAs that will need an amendment to address GDPR. ICANN-accredited registries and registrars have been working together in a joint effort to come up with standard language for these amendments that is acceptable to the entire domain industry to help ease the burden of this process and help ensure all registries and registrars are in compliance. GDPR has also affected many of us on a personal level, as we have seen our personal inboxes flooded with opt-in consent requests from different companies and organizations we interact with on either a professional, personal level. To help put the temporary specification to the legal test, ICANN filed a preliminary injunction against EPAG, a Tucals registrar located in Bonn, Germany. In this injunction, ICANN was seeking to require EPAG's collection of the administrative and technical contact data. There are a few key points I want to touch on with how the court ruled regarding this injunction. The court rejected the injunction, citing the principle of data minimization, saying that the contact data is not necessary for the security and stability of the domain name system. The court also rejected ICANN's comparison of the public interest in Whois with that of trademark registers. Overall, the court's decision undermines the enforceability and legitimacy of the temporary specification. From this, what are the impacts on IP enforcement and brand protection activities? Only thin Whois data will be displayed. This is a monumental shift for the domain industry, who is used to having full access to almost all Whois data. As Staten mentioned, we no longer have a method to directly communicate with the registrant. Currently, registrars and registries may have a web form or an anonymized email. Legitimate interest requests have to be sent to the registrar. The community is still trying to define what a legitimate interest actually is and who will be allowed access to the full Whois data. We will most likely end up with a different tiered access for law enforcement, IT security, IT law, and intellectual property owners. We will most likely see an increase in legal action being taken as subpoenas and court orders will be required to discover registrar information. The bulk Whois Port 43 access has been terminated, thus making any reverse Whois lookup service compromised. In addition, anonymous domain acquisitions and transfers will be more difficult to complete as more manual processes and technology must be deployed to find contact information and registrant data. The brand protection and enforcement community will be dependent on other databases for information regarding websites. I will now hand it back over to Staten.
Great, Sherry. Thanks very much. So I'd like to move us forward, looking ahead now at what needs to be done in the enforcement community to deal with this and maybe make some changes. So we're going to be keeping our advocacy skills up to date or keep pushing our advocacy work that will try to maintain the current Whois system to the greatest extent possible. And that means getting access to that full Whois data that's still being collected. And this includes work on the accreditation and access model that I mentioned before. And what does that look like? So, well, first of all, the access model has been at least acknowledged by the European Data Protection Board, which is the entity now that provides guidance and advice on GDPR compliance. They've acknowledged that access and accreditation to the full Whois data by parties that have a legitimate interest, namely law enforcement, trademark, intellectual property rights groups, should have this access. So what is happening now is a group of companies and public safety organizations and other legal experts have been working feverishly over the last several months to put together an accreditation and access model that we can provide to ICANN and the multi-stakeholder community for consideration and hopefully for adoption. The model covers a number of key elements. One is it talks about the different types of entities that we believe are eligible to look at the full Whois data, mostly the kinds of groups I just mentioned before, law enforcement, trade association, child protection groups, and the like. It has to lay out, because GDPR requires a legitimate and lawful purpose for accessing the data and how that data will be used. For example, if you're going to gain access to send a cease and desist letter or to file a UDRP or a URS complaint, that has to be the stated purpose for accessing the data. There is also we're working on an element on how these eligible entities will be accredited for that data, and a purpose statement is included which describes how the data will be collected and stored and processed by the party requesting the data. It also has some other other key elements, such as a proposed operating model, some terms of accreditation, and proposals for a validation process. There's been quite a few different processes proposed for how the validation of these entities occurs, and that's still to be determined, but we've opened this model out to, as I mentioned, to the community for input, and hopefully be moving that along over the next several months. But that is the key, in my mind, to regaining access to Whois for the purposes which we're all interested in doing, which is keeping the bad guys from doing their nefarious activities using domain names and websites. So I wanted to recap what we at MarkMonitor did to prepare for GDPR, because I think it's helpful to understand for those of you who are clients what we said we were going to do and what we were able to achieve in the run-up close to May 25th. So we scrubbed our Whois database to make sure that we didn't have any natural person data in there, because our cells had to be GDPR compliant. And to that end also, we made our Whois output conform to the temporary specification, and we're building the web form that's needed to relay information to the registrant. So we got to be compliant with the temp spec. We also developed 3 mitigation strategies to aid in our enforcement processes, and those of which I've explained before. But to recap, one was hiring some additional analysts to help us do the more manual work that was required to identify third parties' data and information, registrant data and information. So we hired some additional hands to do that. We also consulted, or the second thing we did was expanded our scanning technology. I'm dropping down a few bullet points as part of our mitigation strategy. We deployed our scanning technology in a little broader fashion so that we could look at the metadata behind certain websites and see if there was any registrant information, such as an email or a name or a contact there that we could use to do enforcement. And we also are looking currently still at some other third-party data sources by which we can use to see patterns of abuse, things that we used to be able to identify during a reverse Whois lookup. We now may be able to identify using other DNS data. So those are the deployed mitigation strategies. We also consulted with expert privacy counsel in Europe on efforts and options to maintain our current Whois. We, of course, advocated within ICANN and to the United States government and to data protection authorities around the world our position on the importance of Whois data being accessible, and those advocacy efforts obviously do not throttle back even after enforcement. In fact, now I think is more important than ever a time to be voicing our concerns about what's happened in Whois now that we've seen it go dark with respect to registrant data, and to provide some data to show the impacts. We also have met with registry operators and registrars to understand the changes that they're going to have to their Whois, and Sherry touched upon that. We saw that in the form of many RRA amendments and other notices. So we're having to keep track of all of those different changes, and I have a person on my team who's actually monitoring all the changes to CCTLD operators and GTLD operators when it comes to their Whois output. I already touched on the scanning technology and the third-party data sources, and of course we've trained our CSMs to find contact data through manual processes using the scanning technology, and to employ the requests for Whois data. I mentioned before that the temporary specification requires registrars and registries to take reasonable requests, or take requests for reasonable access to the Whois data, and that's requiring us to send more of these requests. So the last slide before I take questions relates to some advice we're giving our clients and brand owners generally. If you do a lot of enforcement work using Whois right now currently in-house, you should prepare to do more manual enforcement, because without the Whois data there in the registrant fields, you're going to have to look around on the website to see if there's any data that you can use to do enforcement mechanisms. And if you do find that data, you're going to send those notices to either the registrar of use contact or relay that information through the web form through the web form that the registrar has or the anonymized email address. So assume the registrant is under a privacy service. So in the past, you know, if a registrant has a privacy or proxy service in their Whois and is masking their data, you've had to undergo the same kind of process by sending the notice to the registrar or, you know, having it relayed. That's sort of the approach you'll have to take in this post-GDPR world. And unfortunately, your legal counsel is probably going to get more work as filing subpoenas and court orders to get the registrant data disclosed in many cases will have to be done. For those who are familiar with UDRP and URS processes, the providers, the UDRP providers have signaled that they would be willing to accept Jane Doe complaints if you're not able to identify who the registrant is. So if you believe that the registrant has acted in bad faith, you can still file a UDRP complaint, and the providers are given access to that underlying Whois data. So that is one way to get it disclosed, but as you know, it costs a fee to file a UDRP complaint. Other advice, you can engage MarkMonitor or other third-party providers to help provide and locate that registrant contact information. As I said, we're doing that here at MarkMonitor and be happy to help our clients identify that information. You can use other information in DNS, such as IP addresses and name server data, in order to figure out where the abusers are. So I encourage you to look at that. And also, while I'm on this topic of encouraging things to do, pushing ICANN to implement the accreditation and access model as soon as possible is what I would encourage folks to do. If you need some contact information on where to send notices to ICANN or to DPAs or to the European Data Protection Board, just drop me a note. I'm happy to provide you that information or get your feedback that I can relay in the form of a letter or communications to these groups on your behalf. And finally, GDPR is an ever-changing morass. There's no doubt about it. I would expect to see possible further litigation, possible legislation, other advocacy work happening in the wake of Whois information going dark, registrant information going dark, and I can't, my crystal ball is still fuzzy, but certainly, you know, all of the efforts that many of us are undertaking now to get Whois sort of back online could bear fruit in either short term, hopefully, or in the long term. So stay current on events, and we will endeavor here at MarkMonitor to push out information to you all as it becomes, you know, sort of available, or as information becomes relevant to your IP enforcement work. So going forward, we're going to continue to leverage our technology, our partnerships with folks across multiple industries, and our policy experts, and of course the CSMs here at MarkMonitor to, you know, deliver the same level of white glove brand protection services that you've been accustomed to. Having said that, you know, we can't sugarcoat it, that, you know, it's going to take some time to work through the challenges and roadblocks that now not having Whois is giving us. But we're staffed up, we've got our technology in place, and we're working hard to deliver those brand protection enforcement services that you guys trust that we can deliver. So I think with that, that concludes what Sherry and I wanted to share with you, and we have some time for questions. So I'll turn it over to Brian, who will, I guess, be the gatekeeper of questions, and fire away at us, Brian.
Thank you, Staten and Sherry. Great presentation. As promised, we'll take the next 10 minutes to answer your questions. If you have a question for our presenter, please type them in the chat or Q&A modules in the top right of the WebEx player. Also, be reminded if we do not get to your question, because we've gotten a number of questions during this session, it's a very hot topic, we will be sure to follow up with you afterwards directly. I always answer the first question of the Q&A, and that is, yes, the recording of the broadcast and the slides will be available. As for registering for the webinar, you will receive an email within usually 48 hours of the broadcast with a link that will direct you to the recording and where you can download the slides. So look for that in your email. And our first question, Staten, is assuming trademark infringers are not going to opt in to show their contact information, what is the mechanism you referred to that companies can use to send infringement notices to the registrant?
Thanks, Brian. Great question. So the temporary specification requires registrars to provide either an anonymized email address or a web form or some other mechanism by which communications can be relayed to the registrant. Even though you can't see the registrant email now in Whois, you can still relay information. So when you look at the Whois data, there should be and of course everybody's Whois data is slightly different, so I can't direct you to a specific line in the Whois data, but look at the Whois data and there should be a line that says web form or webmail communication or anonymized email address or whatever. And when you click on that or any instructions related to that, you should be given some details on how to submit a message. So that's one thing. The second way to send a message that you might be referring to is the registrar abuse contact. In every Whois, there is a registrar abuse contact information email address usually, and so you can send your abuse to them, and depending upon what their process is, that will either get forwarded. Most often, it gets just forwarded to the registrant or responded to by some registrar's ICANN compliance department or compliance department. So those are the two places you can send communications through.
Okay, our next question is, with respect to issuing certs, how will companies like Symantec and DigiCerts know where to send the cert if GDPR hides contact information?
Great question. A question more properly directed to the cert providers, so I don't really know the precise answer to that. But what I'm told is that DigiCert, which is Symantec, and other SSL cert providers are looking at other data, DNS data, to triangulate and find out and identify who's behind an SSL cert for validation, or who they can validate for an SSL cert. So I don't know what their level of success has been in employing and deploying, those other data sources, but to my understanding, that's what they're using now to help do SSL validation, whether it be OV, DV, or EV cert. But that's a great question. I wish we had a little more insight into that, but probably more properly directed towards the SSL providers.
Okay. Historically, registrants could pay to anonymize their email and other contact information, ergo via services like domainsbyproxy.com. Do the recent GDPR regulations mean that registrants may now be able to keep their info private without paying?
Yes, that's another good question. So yes, with GDPR now in effect, and Whois being masked, the necessity of having, you know, a privacy or proxy service arguably goes down. It still has its place, though. As I mentioned, registrant organization name is still public. So if you're a company and you want to keep your registrant name, your corporate name, out of Whois, then you'll still want a privacy or proxy service. But if you've been an individual who's had privacy and proxy service, now that you have this masked Whois, the value in having that is probably less from that standpoint.
Okay. Next question is, when is the accreditation and access model, or when are the accreditation and access models expected to be completed?
Well, not soon enough, that's for sure. But let's look at this practically. The model's not baked yet. It really has to get fully baked and sort of, you know, it has to have, you know, sort of consensus support, broad level support within the registrar and registry community and with other stakeholders in order for it to really get adopted. And that's going to take a little time, not to mention that it's going to take time to actually implement the model. Probably we're looking at, you know, 9 to 12 months of, you know, our current dark Whois before we can get accreditation and access model finalized, fully baked, approved, and then implemented. So I wish I could be more encouraging about that timeline, but that's just the reality of the process.
Okay, and next question is, for those registrants outside the EU, will Whois remain unchanged?
No, as I mentioned, registrars can apply it globally, apply the temp spec globally, which means they can mask the Whois regardless of whether you're located in the EU or not. Now, one thing I should mention is CC top-level domain registries, that is country code top-level domain names, do not have contracts with ICANN. They're sovereign. They're run by the governments, and so therefore they don't have to comply with the temporary specification, which means they can look to their own jurisdiction and law and apply, you know, what they think is compliant under the circumstances of their laws. So we have seen, as Sherry mentioned, that some CCTLDs have elected to keep Whois actually up because they don't believe that it applies within their jurisdiction or to their registrants. But I think it's fair to say that overwhelmingly most registrars have taken a rather conservative position and have followed the temporary spec and minimized the Whois output.
Okay, and will the Wayback Machine be impacted?
Yeah, great question. So the Wayback Machine, for those of you who aren't familiar with it, is a tool that's available online for looking at a snapshot of a website at any given time. So, for example, if you wanted to see what Amazon.com looked like in 1995, the Wayback Machine, this is not 100% on every website ever created, but to the extent that the tool provider was able to cache photos or snapshots of what the website looked like back in a certain time, you can see it. This doesn't have any impact on that, right? As far as I know, because I'm not sure that that the tool itself relies on historical Whois data to pull the record or the image that you see for the Wayback Machine. Now, for Whois historical Whois data, so that's data that, you know, has been in Whois. We, along with many other Whois data providers, took a snapshot of the Whois data at the last point that it was public. And depending upon processes and policies, that data can be accessed and looked at for seeing any domain names that were registered prior to May 25th. If there was historical Whois data that was outputted, you may be able to see that going forward. But for any Whois data, of course, for domain names registered post May 25th, you'll get the redacted data. So I hope that answers your question. But to recap, I don't believe that Wayback Machine will be impacted by Whois, because I don't think it's dependent on Whois, historical Whois data to serve the result. But I'm not entirely sure, since I've not dived into the technical delivery of Wayback results.
Okay, we just have time for just a couple more questions, Staten. How can I help legal understand the impacts of elevated legal cases, costs, cycles to research? What do they need to plan out to the increased work?
Okay, that's a great question. So one thing, as I mentioned, is I think your legal team should be prepared to file court orders and subpoenas to get the full Whois data available. If you make a request to a registrar, and for whatever reasons, based on their own probably advice of counsel, they refuse to provide you with the Whois data upon request, then the only thing that you have actually 2 or 3 options. One is you can file a complaint and have it disclosed as a matter of discovery. 2, you can file an ICANN complaint against the registrar for not complying with the temp spec, making the argument that the registrar did not give you reasonable access. So that's another option. A third option that's legal in nature is, as I mentioned before, filing a UDRP or URS complaint with one of the UDRP providers, and as part of that process, the Whois data will be revealed, and you can, make that case. So those are where legal can come in to play at this point. In terms of resources, we work with lawyers all the time, and if your legal counsel would like to, needs information, just let us know if there's anything we can do to provide. If you're a client of ours, we're happy to help.
Okay, great. And our final question today would be, are there any changes on Whois search for domains online method?
I'm sorry, Brian, could you repeat that question? I wasn't sure I caught it.
Are there any changes on Whois search for domains online?
Okay, I'm kind of having to guess here what the audience member meant by who's online. So as I mentioned, the Whois information is redacted with respect to registrant data, but that doesn't mean all of Whois has gone dark, not the full Whois record. So you can still see things such as creation date of the domain name, registrar ID, registrar abuse contact, what else? Name server data. There's a lot of things that are in Whois that still remain. It's just the contact information for the registrant, the admin, and the billing contact. That information is now hidden from you, but a lot of the other technical DNS fields are still available. So to the extent those are help identify where the bad actors are and what they're doing with an infringing domain name or a website, that information can still be leveraged. I think that's what the presenter was, or the audience member was getting at, but I apologize if I missed the substance of the question.
No problem, and thank you, Staten. That was a great answer and a great presentation. Thank you also to Sherry as well. And a big thank you to all of our attendees for joining us today for the impact on Whois and intellectual property enforcement. We got a ton of questions, so we will be following up individually with folks online over the next several days. Please be to answer your questions, and also please be reminded that we will provide a link in an email to you directly so you can watch the recording of today's presentation as well as download Staten and Sherry's presentation. Also, please be reminded, please take a few minutes to complete our brief survey, which will automatically appear as you exit the webinar today. Again, a big thank you, and this will end our broadcast for today. Have a great day.